Why does my kid need a guardianship if I'm still alive? Hi, I'm Neil Tyra. I'm an estate planning attorney in Rockville, Maryland, and I do estate plans for regular folks like you and me. Now, this subject came up this week with some clients of mine who were gracious enough to give me permission to share some of the details of their case with you. And it's a bit complicated, so this might end up being a couple of three videos. But basically, the question has to do with, can a minor inherit directly? And the answer to that is no. So any good, properly written will is going to provide provisions in that will for what happens if a beneficiary of that estate is a minor. And under the Uniform Minors Trust Act, there are a variety of options available to the estate planner and to the client who is drafting such a will. One is that the will itself can create what's called a testamentary trust, a trust that springs into being as a result of certain conditions being met. And the trust can then hold the money until the minor turns of age and can use that money for the minor until that time. A second way is to give it to a custodian. Okay, well, who is the custodian? Well, sometimes parents name a custodian for their child, or if the child has, say, for instance, become a ward of the state is a custodian. So if they inherit, the custodian can hold the money under those same conditions. It can also be held by the executor or the personal representative. That, in effect, is very similar to a trust. Okay, it just means that the personal representative has an ongoing obligation to report to the court regarding those funds. And finally, if there is, well, not finally, there can be a guardianship created. And sometimes a guardianship is created for, in fact, the parent. And that's what happened in this case. Lastly, if it's a small amount, it might be given to the minor directly. So what happened in this case was sadly, the father passed away as a result of a tragic accident. He had a life insurance policy, but instead of giving it to his wife, he named his son as the beneficiary. His son is 11 years old. Unfortunately, the son can't get a hold of that money. The mom, the surviving spouse, the mother has to apply for a guardianship for her own child in order for the court to authorize the release of that money. To me, I think it's a bit egregious, but the whole purpose of this is to make sure that the money goes to the child specifically and is used for the child's benefit. So there's a lot of other nuances to this issue. If you have questions about guardianship of a minor, our information is at the end of this video, and we'd love to have the chance to talk to you about it. Again, my name is Neil Tyra. I'm an estate planning attorney in Rockville, Maryland, and I do estate plans for regular folks like you and me.